Did you know that in Nevada, a seller might actually have to tell you about impact fees? Those charges for new roads and schools.
Yeah, before you even own the place.
Exactly.
Yeah,
It's one of those details that, well, if you miss it, it could really mess with your budget later on.
definitely.
Welcome, everyone, to the Deep Dive. We pull apart these complex topics to get you the info you need. And today, we're tackling residential disclosures in Nevada.
It's quite a landscape, you know. Knowing the rules here can honestly save you so many headaches, whether you're buying or selling.
For sure. The paperwork alone can feel, well, overwhelming.
It really can.
So you shared the official residential disclosure guide with us from the Nevada Real Estate Division. We're going to use that as our map today.
Think of it as a guided tour, yeah.
We'll hit the highlights, the really important stuff, so you can feel more confident, more in control, whether you're buying or selling in Nevada.
And this guide, specifically the July 2017 revision for the selling side, that's our key source. It's official, comes
Yeah.
straight from the division.
Right, so it's legit.
Totally. It covers, well, everything. State disclosures, which we'll focus on a lot, but also federal requirements and even some like local or miscellaneous things.
Okay, so our mission today, make sense of it all. We want to pinpoint the disclosures that, really matter.
Find those aha moments.
Exactly. Those things people might overlook, but can have a huge impact. Okay, ready to dive in.
Let's do it. State disclosures first.
The guide kicks off with common interest communities and condominium hotels. So HOAs and condo hotels. What's the main thing listeners need to grasp here?
Well, what's really interesting is how much the rules focus on making sure buyers know exactly what they're getting into.
Transparency, basically.
Right. The whole point is making you, the buyer, aware of your rights, sure, but also your obligations and maybe most importantly the restrictions, the CC&Rs.
Covenants, conditions, and restrictions. Got it.
And also, it's super important to realize up front, if you don't pay your assessments, well, that could eventually lead to foreclosure.
Okay, serious stuff. And who's responsible for giving the buyer this info? Who provides it?
The seller. It's their job, and it's at their expense, too. They have to give you this information statement.
Is there a specific name for it?
Yeah, it's a bit of a mouthful. Officially, it's like, before you purchase property in a common interest community condominium hotel, did you know? It's designed to be really direct.
Okay, catches your attention. Now, the guide also mentions a public offering statement and something called a resale package. How are those different?
Good question. Think about the timing, like the age of the community. The public offering statement, that's what you get with brand new development.
Okay, new construction.
Or places where they're still building, converting buildings, maybe timeshares are involved, or, stuff registered with SEC. It's broader.
What kind of details are in that one?
It covers the developer's big plans, construction schedules, what amenities are planned, the initial fees, timeshare details if they apply. And here's a key thing. If you haven't actually seen the unit in person, you get 5 calendar days to cancel the contract after you sign it.
5 days. Okay, so that's for new stuff. What if I'm buying a place someone already lived in? A resale.
Right, that's where the resale package comes in. Again, the seller provides it, their cost.
And what's in that package?
It includes that first "did you know" statement, but it goes deeper into the current state of the community.
Okay, like what?
You'll find the declaration, the bylaws, rules and regs, the current budget, financial statements, how much is in the reserve fund for future repairs.
Reserves are important.
Very. Also, info on any lawsuits against the association, current monthly dues, and importantly, any unpaid dues the seller owes.
So public offering statement is for the new community's future plans. Resale package is for an existing community's current health.
You got it. That's a good way to put it.
That's a ton of info for a buyer.
Yeah.
Is there a cancellation period with a resale package too? Like the 5 days for the new units?
Yes, absolutely. Once you get that resale package, you, the buyer, have 5 calendar days to back out of the deal, assuming you haven't already formally accepted the property.
5 days again?
Yep. So smart sellers get that package to the buyer ASAP, ideally giving them that full 5-day window before the contract is totally locked in. Makes things smoother.
Okay. Now, the guide mentions transfer fees and unpaid obligations, but then there's this note about a statement of demand being really important now. Can you break that down?
Yeah, this is a really critical update people need to know about. It applies to common interest communities, so HOAs, but not condo hotels.
Okay, just HOAs.
Right. So it used to be that the resale package was kind of the one-stop shop for all the seller's debts related to the HOA.
But not anymore.
Not entirely. The law changed back in 2013. The resale package still includes a statement about unpaid stuff, monthly dues, management fees, transfer fees, maybe fines, but it's not guaranteed to be the complete picture anymore.
So what's the missing piece? What else do buyers need?
The seller must now get a separate document called a statement of demand. They get this directly from the HOA.
Okay, a separate statement of demand.
Yes. And this document has the final, official, up-to-the-minute amount of anything the seller owes. Assessments, fees, potential foreclosure costs, lawyer fees, everything.
And how long is that statement good for?
It's legally effective for at least 15 business days after the association gives it to the seller.
So the big takeaway for a buyer is,
Make sure your seller gets you that separate statement of demand. Don't just rely on the financials in the resale package. You could miss some big recent debts otherwise.
right, and end up owing money right after closing. That's a huge protection.
Exactly. The legislature saw a need for it.
Okay, really good to know. Let's shift gears. Next up is consent to act. What's this one all about?
Consent to act is about transparency when one real estate agent, one licensee, wants to represent more than one person in the same deal.
Like representing both the buyer and the seller.
Exactly. That's called dual agency. And it creates, well, an obvious potential conflict of interest, right? Whose side are they really on?
Makes sense.
So the purpose of this form is to make absolutely sure everyone involved knows about the dual representation and gives their informed, written, okay, their consent.
What has to be in that written consent to make it official?
A few key things. It has to clearly describe the deal, state up front that the agent is representing more than one party and that there's a conflict.
Okay.
There's also a required confidentiality part. The agent promises not to share confidential info learned from one party with the other party for 1 year after the deal closes, unless a court orders it or they get written permission.
1 year confidentiality.
Yep. And crucially, the form has to say you don't have to agree to this dual agency.
Yeah.
And you have to confirm you're agreeing voluntarily and you understand what it means.
Protects everyone involved.
Okay.
Okay, next, construction defects. What should buyers look out for here?
The main goal here is simple, making sure you, the buyer, know about any known construction problems with the house.
And if there is a defect?
If a defect exists, the original contractor actually has a legal duty to disclose in a very specific way. It has to be underlined, bold, all caps, impossible to miss.
Wow, okay. And what if there was a claim or a lawsuit about a defect in the past?
Then the seller has a big disclosure job. They need to give you, the buyer, a whole bunch of paperwork.
Like what kind of paperwork?
Copies of all the notices sent to the contractor about the problem, any expert reports that were done, the full details of any settlement or court judgment, and a detailed report on all the repairs that were made.
That's a lot. When does the buyer get all this?
At least 30 days before closing. Unless escrow is shorter than 30 days, then they have to give it to you right when you sign the sales agreement.
And what if a defect claim pops up during escrow?
Good question. The seller has to tell you within 24 hours of finding out about the claim. And remember, if the house is in an HOA, all this defect info also has to be in that resale package we talked about.
Got it. Okay, let's talk about something every buyer and seller deals with. The duties owed by a Nevada real estate licensee disclosure. Why this form?
This one's really fundamental. It's meant to make sure both the buyer and the seller understand the legal and ethical duties that every Nevada real estate agent owes to all parties in a transaction.
Even people they don't technically represent.
Yes, certain duties are owed to everyone. The form also clarifies the specific relationship the agent has with the people they do represent, buyer's agent, seller's agent, or dual agent.
And when should someone get this form?
Absolutely critical. Before the client signs any other documents for the deal, you need to know the agent's role and responsibilities right from the start.
Can you give us a quick rundown of some of those key duties?
Sure. The big ones are use reasonable skill and care, keep client information confidential for a year after the deal, with exceptions, work diligently to get the agreed-upon price and terms, present all offers received as soon as possible unless the client waives that duty, which we can talk about, disclose any known material facts about the property or transaction.
Material facts.
Yeah.
Like Significant issues.
Exactly. Also, advise the client to get expert advice, like from inspectors or lawyers when needed, and of course, properly account for any money or property they handle.
You mentioned waiving the duty to present all offers. Why would someone do that?
A client can choose to waive that. They have to sign a specific waiver form from the real estate division. Sometimes, along with that, there's an authorization to negotiate directly with seller form.
What would that allow?
It might let a buyer's agent talk directly to the seller, but only if the seller's own agent agrees to it. Without both forms signed, a buyer's agent usually can't just bypass the seller's agent.
Hmm. As a buyer, I'd want to think carefully before signing that waiver. Why would my agent suggest that? Could it hurt my negotiation position?
That's exactly the kind of question a buyer should ask. Understand the why behind it.
Good point. Okay, let's switch gears. Impact fees. This sounds like it's mainly for people buying brand new homes, right?
Mostly, yes. Impact fees are charges local governments put on new developments.
Why? What are they for?
They help pay for the extra strain new homes put on public services, think bigger roads, new schools, water and sewer upgrades. The disclosure just makes sure buyers of new properties know these fees might exist.
And who tells the buyer about them?
The seller is responsible here. If the seller knows about impact fees for that property, they have to give the buyer written notice.
What does the notice have to say?
It needs to state the fee amount and which government agency is charging it. And this notice has to be given before the property officially changes hands.
What if the seller forgets or doesn't provide the notice?
Well, the guide points out a big consequence. If the seller fails to give proper notice, they could be legally liable to the buyer for the full amount of the fee.
Wow, okay. That's a strong reason for sellers to be upfront.
Definitely encourages transparency.
What about a lien for deferred taxes? When does this come up?
This happens if property taxes were legally deferred, maybe through a program for seniors or something, and those deferred taxes haven't been paid yet when the property sells.
Okay, unpaid back taxes.
Essentially, yes. The seller has to notify the buyer in writing that there's a lien on the property because of these unpaid deferred taxes. That notice happens at the time of sale.
And who actually owes the money?
That's key. The person or entity who owned the property on the date the taxes originally became due is the one legally on the hook to pay them. The buyer needs to know the lien exists, though.
Right. Okay, let's move to manufactured housing. Looks like there are a couple of different disclosures here.
That's right. One for used manufactured or mobile homes, and another specifically about homes staying in manufactured home parks.
Let's start with the used ones not on permanent foundations.
Okay, so if a used manufactured home hasn't been legally converted to real property, meaning it's still titled like a vehicle, as personal property, the main point is to tell the buyer that.
Why does that matter?
Because it means the home is subject to personal property taxes, not the usual real estate taxes. The real estate agent involved has to give the buyer this disclosure form before the title transfers.
Okay, personal property taxes. Anything else key for the buyer?
Yes, a very important detail. The title doesn't legally pass to the buyer until the county assessor signs off on it.
And why does the assessor need to sign off?
That signature confirms that all the personal property taxes owed by the seller have been paid in full. Also, the buyer has their own paperwork to do after the sale. They need to submit docs to the State Manufactured Housing Division and the county assessor within 45 days to get their own title.
Got it. 45 days. Now, what about homes staying in a manufactured home park? What's the disclosure focus there?
This one is all about letting the buyer know that if they plan to keep the home in the park after buying it, they might need the park landlord's approval to become a tenant.
So buying the home doesn't automatically mean you can live there.
Correct. If the park landlord does require approval for new residents, they have to post a clear sign at the park entrance saying so.
And can the person selling the home or the dealer guarantee the park will approve the buyer?
No, absolutely not. The responsibility is completely on the buyer to apply directly to the park management for a lease before they finalize buying the home.
How long does the park have to decide?
Once the buyer submits a complete application, the landlord has 10 days to approve or deny them. It's a crucial step for anyone buying a home they intend to keep in a park.
Definitely. Okay, let's move to something that feels very Nevada. The open range disclosure. What's the point of this one?
Yeah, this is specific to areas near open range. Open range, as the guide explains, is basically unfenced land outside of cities and towns where livestock, cattle, horses, can legally roam free.
So your property might border lands where cows just wander around.
Exactly. The disclosure tells potential buyers that. It also mentions that the property might have unrecorded or unsurveyed county or state rights-of-way across it, sometimes called RS 2477 rights-of-way.
What are those?
They're old historical routes that miners, ranchers, or even the public might still have a right to use for access or recreation.
So buyers need to be okay with potential four-legged neighbors and maybe people crossing the land?
Potentially, yes. The seller must give the buyer this disclosure in writing before the sales agreement is signed, and the buyer has to sign it acknowledging they received it.
Does it say anything about fencing?
It does. It confirms the owner's right to fence their property to keep livestock out, and that they might be able to get damages if livestock break through a proper fence. But it also warns against hurting roaming livestock, even if they're on your fenced property.
Is there anything special about recording this disclosure?
Yes. The seller needs to keep a copy, give the buyer an original signed copy, and this is important, record the original document with notarized signatures from both buyer and seller at the county recorder's office.
Okay, notarized and recorded. Got it. Next state disclosure. Private transfer fee obligation. What on earth is a PTFO?
PTFO. It sounds complicated, but it's basically a requirement tied to the property that says when it's sold, the buyer has to pay a fee to some third party.
A fee just for buying the house, paid to someone other than the seller.
Right. It could be a one-time flat fee or maybe a percentage of the sale price. The disclosure's purpose is simply to make the buyer aware if this obligation exists.
What does the seller have to tell the buyer about it?
They need to provide a written statement describing the PTFO, and it has to include specific legal language, pretty much word for word from the Nevada law.
What does that language say?
It warns the buyer that the PTFO might lower the property's value. And it also points out that Nevada law actually prohibits new PTFOs created after May 20, 2011. Those aren't enforceable. This all has to be disclosed before the property transfer.
Interesting. Okay, now we get to what sounds like a really big one. The seller's real property disclosure. This covers the property's condition, right?
It does. It's probably the most comprehensive condition disclosure. Its main job is to make the buyer aware of the property's physical condition, at least as far as the seller knows, before the deal closes.
But it's not a guarantee.
Absolutely not. Crucially, it's not a warranty or a guarantee, and it's definitely not a substitute for the buyer getting their own professional home inspection. Very important distinction.
Is it required for all sales?
Not for brand new homes that have never been occupied, but for most resale situations, yes.
So what does the seller actually have to put on this form?
They have to fill out the official seller's real property disclosure form completely and accurately. Detail the condition, disclose any defects they know about hidden or obvious, and anything else that might affect the property's value or use.
Can the real estate agent fill it out for them?
No, unless the agent is the seller. The seller has to do it themselves. Every question, usually phrased like, "Are you aware of?" needs an answer. Yes, no, or NA. And if the answer is yes, they must provide a written explanation.
Then the seller signs it.
Seller signs and dates it, and the buyer should only sign it after the seller has filled everything out, including all the explanations.
What happens if the seller doesn't fill it out right or hides a known problem?
There can be serious consequences. As a buyer, if you don't get a fully and properly completed form on time, you can legally cancel the purchase contract without penalty.
Cancel the whole deal.
Yes, and if you close on the house and later find out the seller knew about a defect and didn't disclose it, or if you never got the form at all, you might be able to sue for treble damages.
Treble damage is like 3 times the cost.
3 times your actual monetary damages, potentially, unless you specifically waive those rights, which the guide strongly advises against doing without talking to a lawyer.
When does the seller have to give this form to the buyer?
It has to be delivered at least 10 calendar days before the closing or transfer of the property.
What if something breaks after they fill out the form but before closing?
Good point. The seller has an ongoing duty. If they learned about a new defect or if something they already disclosed gets significantly worse, they have to tell the buyer in writing as soon as possible, definitely before the closing.
Can a buyer just say, don't worry about the form? Can they waive it?
No. The buyer cannot waive the right to receive this disclosure, and the seller can't make them waive it as part of the deal. It's mandatory.
Okay. And I see there were updates in 2017 about solar panels and conservation easements.
Yes, important updates. The form now specifically asks about solar panels. Are they there? And if so, are they leased, owned outright or financed.
Makes sense. That affects ownership.
Exactly. And sellers also now have to disclose if the property is part of a conservation easement program, like the Water Smart Landscape Program in southern Nevada, and it references the specific state laws.
Okay, last state-specific one. Water and sewer rates. Who needs this disclosure?
This one's pretty specific. It applies only when someone is buying a previously unsold home or improved lot, and the public utility providing water sewer serves a medium number of customers between 26 and 1,999.
So not huge municipal systems, not tiny ones.
Right. The idea is to inform these specific buyers about the utility rates. The seller has to post a notice with the current or projected rates somewhere conspicuous on the property.
Post it physically.
Yes, and also give a copy of the notice directly to the buyer before the sale. The notice also needs contact info for the utility company and the State Public Utilities Commission's Consumer Complaint Division.
Okay, that wraps up the state disclosures. That was a lot.
It is quite a list, but important stuff.
Definitely. Now let's move into the federal, local, and miscellaneous category. The big federal one everyone knows is probably lead-based paint, right?
Absolutely. That's federal law, applies nationwide to any house built before 1978.
Why 1978?
Because lead paint was banned for residential use that year. Older homes might have it, and it's a known health hazard, especially for kids.
So what does the seller have to do?
They must disclose any known lead paint or hazards in the house. They also have to give the buyer the EPA pamphlet, Protect Your Family from Lead in Your Home.
The EPA pamphlet, okay.
And any records or reports they have about lead paint in that specific house. This all happens before closing on a specific federal form.
What rights does the buyer have?
The buyer has to sign acknowledging they got the pamphlet and reports. They also get a 10-day window to have their own lead risk assessment or inspection done if they want. They can waive that 10-day period, though.
Okay. Moving to local and miscellaneous. I see pool safety and drowning prevention. That seems very relevant for Southern Nevada.
Extremely relevant. This comes from an agreement between the State Real Estate Division and the Southern Nevada Health District.
What's the goal?
To raise awareness about drowning risks, especially for young kids under 4 in pools, it's a huge issue in Clark County.
Does the seller give a separate form for this?
No, not a separate form, but the critical pool safety info is actually included within that main residential disclosure guide we've been talking about.
Ah, so the buyer gets it as part of that package.
Exactly. The guide points people to the health district's website for more prevention tips and stats. It highlights that drowning is a leading cause of accidental death for young kids there, often in family pools because of, unattended access.
Sobering reminder. Okay, the guide then lists a bunch of other miscellaneous things. Airport noise, zoning, environmental hazards. What's the general theme here?
The big theme is really buyer beware, or maybe more accurately, buyer be aware. Do your homework.
Meaning the seller doesn't have to disclose everything.
The seller has to disclose known hazards, but the guide makes it clear. Just because the seller doesn't know about a problem doesn't mean it doesn't exist. So the responsibility really falls on the buyer to investigate things they're concerned about.
What kind of environmental hazards does it list as examples for Nevada?
Things like radon gas, flood zones, potential meth labs. There are specific laws referenced for that. Wood-burning devices, underground oil tanks, septic systems, wells, land contamination, groundwater issues, public pool spas, mold, and moisture.
Wow, quite a list.
Yeah, and for each one, the guide usually gives EPA website links for more info. Same idea for airport noise or zoning rules. The buyer should check with the local city or county directly.
Okay. There's also a specific gaming disclosure, but only in certain situations.
Right. This applies only in counties with over 400,000 people, so Clark and Washoe mainly. And it's only for the initial purchaser of a newly constructed home near a gaming district.
So first buyer of a new build near casinos.
Pretty much. The seller of that new home has to give the buyer a copy of the latest gaming enterprise district map, show where the nearest district is, and warn them the map can change.
When does the buyer get this?
At least 24 hours before the seller signs the sales agreement. The buyer can waive that 24-hour review period, though, and the seller keeps a copy.
Got it. What else is in this miscellaneous section? I see FHA home inspections, military activities.
Yeah, quick hits on those. For FHA loans, there's a notice telling buyers that the FHA appraisal isn't the same as a home inspection and strongly recommending they get a separate inspection.
Good advice regardless of loan type.
Absolutely. For military activities, if the property's in Clark, Washoe, Churchill, or Mineral counties where they have official military activities plans filed, Buyers get a heads up about potential training or operations nearby. They suggest contacting local government or the military base PIO for details.
And it mentions licensee disclosures again.
Just reinforces that agents have duties beyond the main forms, like disclosing relationships with parties or if they have a personal interest in the property.
Okay, almost there. Just two more quick ones. Road maintenance districts and soil reports for new construction.
Right. If the property is in a road maintenance district, the seller can't actually sell it unless they give the buyer notice about any district assessments charged in the last 2 years, or since the district started if newer.
So potential road fees.
Exactly. And for new construction, if the buyer hasn't lived in the house for more than 120 days before it's finished, the seller has to tell them when they sign the contract if a soil report exists for the lot or subdivision.
A soil report.
Yeah, if one exists, the buyer has 5 days to ask for a free copy, the seller then has 5 days to provide it, and then the buyer gets 20 days to potentially back out of the contract based on the report unless they waive that right in writing.
20 days to review the soil report. Wow.
It gives them time to assess potential foundation issues, things like that.
Okay, that is an incredibly thorough rundown of Nevada disclosures. It really drives home how much information is involved.
It really does, and you can see how all these disclosures are ultimately there to protect everyone, buyer and seller, by making the whole process more transparent.
It might feel like a lot of paperwork.
It can, for sure. But understanding these key requirements really does lead to a smoother transaction, less stress, fewer surprises down the road.
So, quick recap for listeners. Key things to remember. If you're buying in an HOA, demand that separate statement of demand.
Crucial, don't skip that.
And if you're near open range, well, be prepared for maybe seeing some cows.
Haha, potentially. And remember, the seller's real property disclosure is the seller's knowledge, not a replacement for your own inspection.
Always get an inspection. So if listeners want to read the full guide themselves,
Absolutely recommend it. Go straight to the source, the Nevada Real Estate Division's website, red.nv.gov. You can find the complete residential disclosure guide there, plus lots of other resources.
and of course talk to the pros.
Always. Your real estate agent, maybe an attorney, especially if things get complicated. Get advice tailored to your specific situation.
Definitely. So that brings us to a final thought to leave our listeners with.
Yeah, thinking about all this information, the sheer volume of disclosures, it makes you wonder, what role could technology play in the future?
How so?
Well, could tech help simplify this, make it more transparent, ensure all this critical info gets communicated effectively, maybe in a more user-friendly way, ensure timeliness?
Streamlining disclosures through tech. That's a really interesting question to think about. Could it make things easier and maybe even safer for everyone?
Potentially.
Yeah.
Something to ponder.
Indeed. Well, thank you so much for walking us through all of that. This has been incredibly insightful.
My pleasure. Glad we could dive into it.
And thank you all for joining us for this deep dive into Nevada residential disclosures. We hope it's given you some valuable clarity. Until next time.